Good morning, everybody, and welcome to our webinar on Mexico and United States transfer pricing developments. We're delighted that you are able to attend. Sarah, can you explain how the attendees get the slides and everything before we start?
Yes, welcome everyone. We will, if you have any questions once this webinar is finished, please feel free to reach out to myself. We will send follow-up emails in the next few days, including a copy of the recording of this presentation and also these slides, a PDF version of these slides. And yes, I'll pass it back to Alan to get us started.
If you could advance it to the speakers. I'm really delighted that we have the opportunity to do this program with colleagues from our Mexico office and a featured speaker from Mexico. And I'm going to ask each of our speakers to just briefly identify themselves. Mario, if you could start, please.
Of course, Alan. Thank you, and thank you all for being here today. I am Mario Barrera. I'm an attorney based in Mexico City. I deal mainly with international taxation issues, including transfer pricing. And again, it's a pleasure to be here. Thank you.
Mr. Dawson.
Good morning, good afternoon. I am Jim Dawson. I'm a partner out of the West Palm Beach office. My primary area of focus is federal tax litigation. I have previously worked at the Office of Chief Counsel for 13 years, trying cases on behalf of the IRS. And then I went to work for a large Fortune 200 corporation. Now it's my pleasure to be working at Holland Knight.
And you wanted to do this in Spanish, Jim, I think.
Claro que sí.
Josh, my neighbor.
Yes, hello, neighbor. Hi, I'm Josh Odintz. I'm a partner in the Washington office, Holland Knight. My practice is a three-legged stool of tax planning, tax controversy, and tax policy, and I work with clients on addressing their inbound and outbound needs.
And Sergio, who is based in Houston, is with a company, and we're delighted that you can join us, Sergio. So give us a little background about yourself, please.
Thank you, Alan. Yes, my name is Sergio Vasquez, and I'm the global head of transfer pricing for CEMEX. CEMEX is a company in the building materials sector with revenues around $14 billion. And well, it's a pleasure to be here with all of you.
Well, thank you. So, Sarah, please move to slide 3. Our program is divided into several parts. First of all, we're going to give some background on different work streams to resolve transfer pricing issues. And I think you'll find this interesting about some of the work streams that Mexico has or Mexico doesn't have, and how certain Mexican entities are resolving their transfer pricing issues. Secondly, we're going to speak about the recent IRS Interim Guidance on the review and acceptance of advanced pricing agreements, which I think has made the approval process for requesting APAs perhaps a little bit more difficult. And we're going to describe that process and how it applies to bilateral APAs with Mexico. And then our colleagues from Mexico will give their reaction to this guidance and how they believe Mexican U.S. entities should navigate the guidance. And then fourthly, we will address a number of issues relating to the Mexico-U.S. income tax treaty. Sarah, if you could advance the slide, please. This just sets out what we're going to be talking about in a little more detail. And you can see in part 4, we're going to talk about how to notify that there's a transfer pricing adjustment under the treaty, the maquiladora developments, and then also the scope of business profits. If you could advance the slide, Sarah, please. And if you have any questions or comments, I guess, Sarah, they should use the chat box to send in the questions. We're going to now start with the background, and Jim Dawson will go through, and we should be at slide 7, please, Sarah.
So again, good morning. Let's talk about what we're here for. A transfer price is, I'm going to state the obvious, it's the most contentious tax issue for multinational entities. And the multinational entities have various options. The transfer price study, which we'll get into shortly, APA, which we'll discuss shortly too. And I want to focus really on the alternative work streams that in the guidance are of primary importance that multinational entities be aware of. The first one is the International Compliance Assurance Program, or known as ICAP, which is an OECD Forum on Tax Administration initiative that allows multinationals to voluntarily undergo a joint risk assessment by multiple tax administrations. Unlike an APA, which is legally binding on tax administrations and taxpayers, ICAP offers nothing more than a non-binding outcome letter awarding a taxpayer a risk rating. Then there's the joint audits, which is a fully coordinated examination with the tax administration of a foreign partner, which includes all compliance activity potentially subject to mutual agreement procedures and report guidelines. The compliance activities is accomplished through the joint audit team operating within the legal authority of the applicable international exchange agreements. Now, before we got on the panel, on this panel, Sergio, you mentioned something about the CAP program. Could you explain that to the audience?
Sure.
For your company?
Yes, sure. Basically, CEMEX, the main countries where CEMEX operates are the USA, is the main country, and then Europe, Mexico, Middle East, Africa, and the Philippines. In particular, in the USA, CEMEX was invited some years ago to participate in the Compliance Assurance Program, or CAP. And we have seen that this program has been very useful for CEMEX because in addition to have or to make a very good relation with the tax authorities from the IRS, this program was very efficient because basically our tax return had been audited in a spot, and all years up to 2019 have been audited and closed in a very efficient and practical way. So our experience again in the CAP program has been very useful and very successful for the company.
And Alan, if I can ask you a question, as to ICAP, do both parties have to be able to participate in ICAP, or how does it apply if I want to do an ICAP program?
Well, it's very interesting you raised that, Jim. We had done this program a little while back, and we had a representative of India, and they also were not part of ICAP. There are about 22 jurisdictions that participate. And today, as I was just preparing for the program, I found the IRS website on ICAP, which has a number of FAQs. And what they seem to indicate is that even if one of the parties or counterparties is not in the program, the IRS will consider the program. And they make the point throughout the FAQs that before considering ICAP, one should call or contact the program. And as we will see a little later in the elements that the IRS considers in this new interim guidance, there are a series of factors the IRS looks to determine whether it would be appropriate to do ICAP. The point with ICAP, I think, as opposed to the APA, one, it's quicker, takes about 24 to 28 weeks, which would be really a very speedy APA, which doesn't happen. And then secondly, it doesn't provide the legal certainty. And if you look at the OECD guidelines for ICAPs, it involves a series of jurisdictions which have to sign on to doing the thing, and you get a non-binding comfort letter. But I think, as Sergio was saying, maybe the expenditure in another type of work stream, which is less time-consuming and onerous than an APA or bilateral APA, might be a good way of dealing with your issues, depending on the specific circumstances. And then when we're dealing with the joint audits, Jim, you have to make sure that all the countries are on the same years, and there's a risk of adjustments and expenditures of resource and government experience. So you have different flavors for dealing with these different types of work streams. But now, unless there are any other comments or questions from anybody, we're going to move to some of the basics of the APA. And Josh, if you can take us through that, that'd be great.
Yep. Can we move to the next slide? If we could go to slide 12. Thank you. So Atma is the part of the IRS that administers the APA program, and its mission is broad. It's to administer the programs within its jurisdiction in a manner consistent with the U.S. tax treaty obligations, and in a manner that secures the appropriate tax bases of the U.S. treaty partners, prevents fiscal evasion, promotes consistency and reasonableness in outcomes, and provides taxpayers with access to competent authority assistance and to the APA process in accordance with considerations of principled, effective, and efficient tax administration. So let's unbundle that and look at some of the features of Atma and the APA program. If we can go to the next slide, Sarah. So first, the APA process is completely discretionary. It is up to the IRS or for Atma to apply its mission to look at a specific request, but it's completely discretionary. And as a result, unlike other actions of the IRS, it is not subject to administrative review. That includes the decision to not accept a taxpayer into the program, to initiate, to suspend, or terminate an APA process. Recently, when there's been litigation over the role of an APA, is it a binding contract? The answer is yes. And to the extent that the IRS seeks to terminate an existing APA, once an APA is entered into, it is treated as a contract for purposes of the law. And what we saw in the Eaton case, that the IRS decided to terminate the agreement, and under the terms of the agreement, it could not do so in its discretion. So this is an ongoing litigated issue. We have one circuit speaking to the issue. I'm sure there'll be other circuits that will speak to the issue in the event that the IRS decides to terminate an agreement. An APA is limited in scope. It is limited to the specific taxpayer, doesn't apply to anyone else, the taxable years at issue, and the specific transactions delineated in that APA. If we can go to the next slide. So the APA program used to be housed in Chief Counsel and the taxpayer operations with an LB&I. In 2017, it was moved over to a new operation, transfer pricing, treaty and transfer pricing operations, or TTPO. Atma is a pretty lean organization considering its broad mission and the number of issues it handles. It has currently 59 team leaders, 26 economists, 9 managers, and 3 assistant directors. And each assistant director oversees 3 managers who lead the team that consists of both leaders and economists. Atma predictably is divided across the United States to take into account those places where one might see a lot of APA activity, which includes Washington, D.C., Northern California, so San Francisco and San Jose, Southern California, LA and Laguna Niguel, and then Chicago and New York. Next slide, please. Let's talk about the most recent statistics. So, pursuant to a congressional requirement, the IRS or Atma issues its statistics on APAs every year. And the most recent APA report for March, I think, is interesting. So we've seen an increased demand year over year, over the last year, to 183 applications compared to 145 in 2021. But we've seen a decrease in the number of APAs that have been executed. So 77 compared to 124, which is the lowest number of APAs executed since 2011, or the tail end of the financial crisis. Even though we've seen a decrease in the number of APAs executed, the time lag to execute a bilateral or unilateral APA has increased by almost a year. So we're definitely seeing a slowdown in the process. There are now 564 pending APAs compared to 461. Unfortunately, the IRS staffing has decreased, but we hope with the additional funding and in the Inflation Reduction Act, I believe it's now close to $60 billion, that we'll see some of that funding spent in bulking up Atma. Mexico accounted for about 5% of pending bilateral APA requests. And for those of you who have been involved in the APA process, it's no surprise that our, I think, most robust APA partner is Japan, with accounting for almost 40%. Next is our trading partner to the north, Canada, at 14%, India at 8%, and then finally all the way down to Finland at 3%. There's a range of transactions that are covered in APAs, from inbound companies and inbound transactions to tangible goods sales and the provision of services. I think the bottom line, or the takeaway for the 2023 report, is that we have an increased demand, we have fewer staff, fewer executions, and increased processing time, which is not great, considering even more pressure coming with the 2 pillars on ensuring where income is reported and booked.
All right. Josh, in terms of the pillars, what is your sort of forecast as to how it may impact the APA program?
Yeah, so clearly, I think companies are going to look for certainty, and one way to achieve certainty is through the APA program. I expect APAs to take on greater importance under both pillars to determine and figure out where income should be reported. That will help companies manage, in the case of Pillar 2, whether a company is under or over the 15% effective tax rate.
It's interesting. The APA program has been in existence for probably a little more than 30 years, and to see where it's evolved is informative. And I think, as Josh mentions, with the pillars coming, we'll see how all of this is impacted, because it is a program which gives certainty, but it's time consuming and resource and financially expensive. We now are just going to preview how the current IRS guidance and practice, and we're on 17, Sarah, will be impacted by this new interim guidance. And basically, you can see that the service came out with a extremely detailed revenue procedure or administrative guidance as to how one should prepare and the information that goes into one of these APAs, be it unilateral, bilateral, or multilateral. And to say the least, the required documentation to substantiate the request is substantial and detailed, and you follow a template which is contained in the appendix to the Rev Proc. And since the inception of the APA program, there's really been an expectation by US taxpayers that if they file one of these things, the request will be granted, and then it's just a question of working out the terms to the satisfaction of both the IRS and the taxpayer. And that should be compared to the situation in various foreign jurisdictions if you're dealing with a bilateral APA, because some foreign jurisdictions, such as the UK, only will take on an APA if it's a sufficiently complex matter, whereas in the US, there are numerous APAs, unlimited risk distribution agreements, and other types of sort of more common transactions. The IRS has announced that the revenue procedure, this 2015-4, is under review, and I think additional changes will be seen. One of the complaints has been that the information required based on the templates is so massive that it would be great if in certain situations, such as renewals or other situations, the amount of information could be decreased. In my experience, we were doing a renewal of an APA before the revenue procedure came out, and the requests and the exhibits were of modest length. And then when the revenue procedure came out, the request, but particularly the exhibits were increased exponentially. What I find interesting, when we did one of these things during COVID, we filed the whole thing through one of the big four firms electronically. So the only thing all of us had to do who worked on this thing were look at the computer, put in the stuff, and then the thing zoomed into the Atma office without any real paper going to the office, which was an interesting phenomenon. We're now going to get into this interim guidance, and we're on page 20, please, Sarah, which came out in the end of April. And from the preamble memorandum to the actual instructions of the guidance, and this was issued to all LB&I personnel, but particularly those that deal with transfer pricing, as Josh had mentioned, the Atma, the Advanced Pricing Mutual Agreement Office, is within the LBI. The preamble states that the APAs are resource and time intensive and really constitute a substantial portion of the Atma caseload. Other parts of the caseload would include competent authority agreements, and then non-allocation cases, which are treated by the treaty assistance portion of Atma. And the service based really on sort of its internal workings as well as the BEPS guidance, was desirous of sort of doing things in an efficient and timely way to promote good administrative practice and to resolve cases in an appropriate and timely manner. And in view of the time, both personnel and financial resources, it was important from the IRS point of view that the work stream chosen to deal with the transfer pricing matter merited the or was commensurate with the resources that would be devoted to the matter. The preamble further says that the intent of this new guidance is not to deal with the proper analysis of transfer pricing regulations, or more importantly, to limit or decrease the number of APAs accepted by Atma. And as Josh went through, you have decreasing personnel getting a heavier and heavier workload. The goal here is, at least according to Atma, to provide an early warning mechanism by going through the steps which we will be describing to identify potential roadblocks to successfully conclude a proposed APA. And if there is a roadblock, opportunities for other paths of certainty. Josh, in terms of Eaton, some commentators have said that a reason for this new guidance is the Eaton case. Do you have any sort of thoughts on that?
Yeah, I mean, certainly, and I think we're going to see in the near term, as in within the next year, that's near term for the IRS, we're going to see a revised RevProc for APAs that I think will give the IRS more flexibility on, from a contractual perspective, on how it can terminate an APA. But yes, I think that, you know, the IRS is certainly aware of the Eaton case and is looking for more flexibility or more outs in the event that there's a broader disagreement about issuing an APA or remaining within an APA. Jim, I think you have some views too.
Jim.
Yeah, Alan, I mean, you know, Josh brings out a good point about Eaton. I mean, the service did not like the results that were being reflected, even though Eaton had filed amended returns during the years at issue under the APA. The service still objected and was fighting hard to revoke the APA. What I find interesting not only is Eaton, but one of the other reasons that, call me cynical, but the reasons for issuance, APA was designed to give both the service and taxpayers certainty. And now you have Eaton, and now you also have, in other cases involving transfer price, the government has been successful in litigation. They've won quite a few cases to the surprise of taxpayers. So I'd like to hear from Alan, Joshua, and Mario. Do you think that the recent successes by the IRS, could that be one of the reasons why now this informal or this these reasons, I mean, in terms of resources, are popping up? Or is it just that the government now is successful in their transfer price cases? Josh, if you have any thoughts?
Yeah, so I think the IRS is concerned about what's going to happen with map requests under Pillar 2, and they're effectively clearing the decks. I think the new guidance will make it harder to get an APA this year, or to go in for an APA this year and perhaps next year. But it will give the IRS an opportunity to slow down their backlog of APAs and then be able to retool and bulk up for what I think is going to be some fairly vigorous disputes under Pillar 2. And that especially will come into effect when the UTPR comes into force, if it ever comes into force. But that is, you can imagine disputes over some fairly simple but important issues that will lead to a, recomputations of the top-up tax. So I think this is about getting ready for what's going to be a very tumultuous period for Atma in the second half of this decade.
What's interesting, Jim, and Josh's point there is really something to keep in mind. Is that in terms of the language which we're going to go through, which is very detailed and explicit, is what one has to do, not only in examining the factors why a taxpayer is going for an APA, but these alternative work streams, and not to sort of advance what the outcome may be. I was listening to the webcast not too long ago where the acting director of the APA program was on and being quizzed about this interim guidance. And if you look at the guidance as we go through it, it seems there now will be a very detailed examination of the reasons why a taxpayer is going for an APA and the possibility of using one of these alternative work streams. But when the alternative work streams were mentioned, the acting director of the APA seemed to say that Atma is in the business of granting APAs, and these work streams may not be of that much consequence. And if that were the case, I query why the guidance came out in so much detail. I think we'll see what happens, but I mean, to sort of turn the question back to you and being a litigator, what would you tell a taxpayer generally about should you use sort of the more traditional controversy procedures or go for an APA? I know that's fact specific, but let me put you on the spot anyway.
When I worked for the company, for the Fortune 200 corporation, the tax executives and the CEOs always wanted certainty. So I'm going to talk against my own interests. I would always recommend an APA. It gives you the certainty that litigation does not provide. We can always look at all these cases. Eaton, Coca-Cola, they go on, especially in the 482 issue, they go on for years and years. They're expensive, and all they do is provide uncertainty. And all you see is the case going between the tax court, the appellate court, and back to the tax court in terms of methodology. An APA gives you, it's a lot of work, a lot of time investment, but it does give you the one thing that litigation can never provide, certainty. So, Alan, against my own interests, I would say go with the APA.
And if I could chime in, Alan,
Sure.
it also, look, once you're in the program, then there's also the possibility of a renewal of that APA.
Yeah.
So if you do the spade work up front and get the team comfortable, there's opportunities to provide that certainty not only for the period you specified, but really in perpetuity. And that's a really valuable feature of the APA program.
And
that's excellent.
I think you also need to consider the country. I mean, I know this is a US-Mexican webinar, but I think you need also to take in consideration the country where you want to have an APA. For example, in our case, or in my opinion, getting an APA in a country in Latin America, probably different than Mexico, is complicated, no? Because we know that the experience that the tax authorities in certain countries in Latin America are not the same as the experience that the APA team in the US or in UK or other countries in Europe has. So probably to have an APA in this type of countries where they don't have that experience, it will take much more time. It will you will need to dedicate a lot of money and time, and the certainty that you will probably get from the APA, it will not be very easy to find, because probably it will take much more time than it will take in the US or in Europe, and maybe the results of the APA will not be the ones that you want. So I think you need to take that also into consideration. Of course, not talking about the US, but probably in regards to other countries.
What's interesting with your comment there, Sergio, I have one matter where we are working on renewals. We've been going on with this for 20 years. And it was a complex initial matter, which involves an EU country. And the time before the current request for renewal, which was a bunch of years ago, we got the APA rather quickly because the methodology had been agreed upon between two sophisticated tax authorities, one being the US and the other this European country. And there were just some minor issues that we had to provide, and so we got the thing. When we renewed the request for after the 5-year cycle expired, the time frames between and we submitted the thing early, between hearing from Atma and then doing our sort of initial interview and then having a position paper and so on, were rather delayed. Part of it might have been due to COVID, but it was just the time frames were much expanded, and we'll see that under this new interim guidance, they have specific rules for renewals, and our client was rather disturbed, saying, well, it hopes that when it gets this renewal, and we're nearly finished with the thing, that it could get a subsequent renewal. So we'll see how all of this works. But on page 21, Sarah, what we have the guidance doing, and we're going to get into some of the nitty-gritty, and I want to hear comments from our group, both from the US and Mexican side, about this as we go along. It now provides a specific process, criteria, and personnel in terms of evaluating an APA request. And unlike sort of the methodology for doing these things beforehand, there's a real emphasis on a pre-file memo, and we'll get into that in a moment, to give the Atma folks and others within LB&I, and for the first time it involved are not only non-Atma transfer pricing exam people, but also the foreign country, an opportunity to consider the request. Whereas in the past, as we'll see, there were limited circumstances where a pre-file was required. Now, under the new guidance, a pre-file is really encouraged and is the way to do, to set forth everything for the review. And there will be a review, as we'll see, in an expedited basis, and then the reviewers on a non-dispositive basis will give their recommendation. And this is all based on reviewing the request, considering it from an APA or one of these alternative workstream solutions, and then saying which is the best way to solve this issue, again, with a concomitant and commensurate expenditure of human and financial resources. And the guidance of the interim guidance says it's going to be incorporated in the IRM in the next 2 years, and obviously will form part of this new IRS revenue procedure. So getting into the guidance on page 22, How will all of this work? Well, the first thing is just certain things which it doesn't impact and certain things which it does. First of all, the interim guidance does not modify the information required to be included in the taxpayer's request. And all of this stuff is contained in the RefProc, particularly the appendix. It doesn't not modify the requirements if a person, the taxpayer wants to file a unilateral APA or to have an abbreviated APA, and if they're complex intangible issues, that's when pre-filing memorandums were required. It doesn't impact any of this. It is dealing with discretionary pre-file memoranda, and which can be done apparently on an anonymous basis. And it's this providing the information for Atma to review to give an initial sort of word as to where they see this thing going. And what is interesting and also complicating about the detailed instructions is they have a very complex sort of flow chart to make the evaluation. If we go now to page 23, we can see in a simplified, totally simplified flow chart what occurs. So you gather the information that you want to submit in a pre-file memorandum, and it's usually a good course to speak to the Atma official who is involved with the country you're going to do the thing with, and the Atma website contains the officials who deal with specific countries, so it's easy to find which person or persons you should contact to sort of discuss pre-file. So you prepare this pre-file memoranda, and there's some guidance in the RevProc about how you do that, and you put in what you think is necessary to inform the Atma persons about the company and what you're requesting and the APA and so on, the covered issues and da. And the intent is to provide taxpayers with information in advance of their undertaking to draft and submit a formal APA, which is, as I mentioned, massive and time-consuming and expensive. And the sequencing is as follows. You file this pre-file memo. The APA team then has detailed instructions as to how to evaluate the filing. And if there seems to be a positive sense that the taxpayer should file a formal request, then the taxpayer would file the request, where that information and other information again will be reevaluated. And only when the APA is filed and reviewed again do you move forward. So the IRS has sort of two shots to figure out if it wants to permit the taxpayer to file an APA request, first in the pre-file, and then secondly, when it gets the APA request. And even if a taxpayer says, oh, I'm not going to do this pre-file stuff, but just file an APA, the first criteria for filing or reviewing the APA is to review all the information which the pre-file memorandum would require to be reviewed. So I think it makes sense, both from an expenditure of resources and time and financial resources, to do the pre-file. And if we go to 24, the outcomes will be that the APA is, that the request is well suited for an APA. And we're going to get into these factors. Whether another potential work stream is recommended is more effective to solve the problem, or where more information is needed. And we're going to look at the factors in the next few pages to go through that. Once a pre-file is filed, the Atma will get back to the taxpayer within 4 weeks orally, or if there's additional information required at a later time. And if an affirmative response is received, the taxpayer would file the APA. On page 25 is some of the sequencing about who's looking at the pre-filing memo and who is involved in reviewing the request. And it's rather complicated when you look at the detailed instructions, which we're not going to cover, but it's who's doing what to review the thing at a particular point of time. And the other point to make in the third bullet is that if there is positive finding to go ahead for the taxpayer to go ahead to file the APA, that does not bind the APA. It merely just is an advisory recommendation for the taxpayer to file it. And here on page 26 and 27, if we can go to those pages.
And Alan, if you
Yes.
allow me to, in regards to the profiling, we have an experience some years ago, I think around 2010. We wanted to do intangible transaction between our US business and Switzerland. And we decided to go for an APA. And well, we did the profiling meeting. We met with the APA team to explain the case, to explain the transaction, and basically, as I mentioned at the beginning of the conversation, CEMEX is in the building materials business. Basically, we produce cement, ready mix, aggregates for the construction. And when we explained the case to the APA team during the profiling process, and basically the team, after we explained all the facts, circumstances, the transaction that we wanted to do, they conclude that a building material company like us cannot have intangibles, meaning that we cannot have created intangibles in our business, which of course is not true. So they didn't want to proceed with an APA on this transaction. And basically what we did was to do the transaction and to document the transaction as if we were filing an APA. So we had all the documentation prepared just in case it was audited based on the experience we gained during the pre-filing meeting.
That's an interesting situation, and I think what this new pre-filing procedure is about is that sort of thing, but on steroids. And if you look at the factors, the first one, does the matter rise to a level of significance that justifies the use of resources to complete an APA? We had sort of raised the question, does that mean that it has to be more than simple, complex, but if it's too complex, they're not going to consider it? And in sort of public comments, someone within the APA world said, no, that's not what we intend. But I think, going to your point and not going to your case, obviously, But if the thing looks pretty simple, they might say an alternative resource may be a better way of doing it. I think a very important point is in terms of bilateral APAs, how will the treaty partner deal with this? Because there has been a real concern by Atma that they approve the request, the taxpayer files the thing, wanting to do a bilateral agreement, and then down the road somewhere the treaty partner says, oh, we're not interested in doing this, and we are going to back out, and you've wasted a lot of time and effort. Josh, you said there's a question here?
Yeah, if you look in the Q&A, so one of our attendees asked, can the panelists speak to what a taxpayer could do if their APA request is denied in the pre-filing process under the new guidance, especially when the alternative transfer pricing work streams are often not efficient and don't provide certainty as that provided by an APA?
At least let me start with this, and I welcome the comments of my colleagues. I don't think there's that much you can do. The APAs are discretionary, and I think the way I would approach this is you need to look at the guidance in close detail, which we're not doing today just because these factors go on and on and on. And then really analyze whether doing this would make sense. And I think if you get some sort of a initial denial is to go back and see if you could convince the persons, or maybe going up to the next level. But I don't see that there's too much recourse. The other thing, if it's bilateral, is to try and influence the treaty partner to chime in on this. But Jim or Josh or Mario or Sergio, what are your thoughts on it?
Sergio gave a great, situation in terms of when he got denied. That's one way to do it. Bottom line is, Alan, you said you got to now prepare for the potential that that you're going to have an audit, do your transfer price study, have the documentations that support it, and then if you are in the CAP program, I don't know if the taxpayer is not or not, but if you're on the CAP program, as Sergio spoke also before, you invite the auditors to come in and review the situation to try to get you as much certainty as you can. If you're not in the CAP program, then like I said, just prepare, have your transfer price study and the underlying documents, and prepare for an audit. Josh or Sergio, do you have any comments, please?
Yeah, no, I agree. I don't think there's, other than contacting the other government, the other competent authority, that's probably the best path. But you're right, there are limited opportunities, and certainly, while we're not going to dive deep into these factors, some of these factors are outside the control of the taxpayer, and so you really won't know which factors the IRS or Atma is looking at. They could be based on your individual facts or their backlog, their caseload, but items that are outside of your control. So it's a bit of a black box, and unfortunately, there really is limited recourse.
When I look at these factors, I call it the Goldilocks. Not too hot, not too cold. Can't be too complex, can't be too simple. Who's going to make that call whether it's complex or too simple? That's outside your control. You may think, if you speak to corporate America, when it comes to complex matters, that's exactly where they want the certainty. That's where an APA in their mind is why they're willing to incur the cost. Yet this criteria says if it's too complex, whatever that means, no, you're not going to be part of the APA. For me, we're basically the IRS right now. I'm trying to figure out what they're thinking in terms of their mentality. Are they truly inviting litigation, or are they inviting taxpayers to become look at these alternative methods that may or may not give you certainty, or are they forcing taxpayers to get into the CAP program? For me, that's an unanswered question.
And if you look at these factors on the bottom of page 26, the factors to go into ICAP, you'll see it's the scope, materiality, and complexity, the sort of the interaction of the company with the IRS, and the transparency and cooperation and examination history. And if we go to 27, you see other factors, if there's sort of a joint audit, but I think, not to repeat myself, advisors and the company have to pay really close attention to these multi-factor tests to make a sort of the best determination they can prior to doing the pre-file. And I think the other point I would make, I have found really in the years I've been doing this, since the inception of the program for 30 years, the one thing I found, these folks at the IRS are really very open and welcoming of calls and discussions and questions and so on. And so I think the advisor or the company, whatever the situation is, really should pick up the phone and talk to the folks in these offices, because there, I think, is really intention to be helpful in proceeding with the transfer pricing situation. So if there are no other questions on the pre-file, and assuming the taxpayer wants to go along with whatever is mentioned, but we're going to turn it to Josh. But let me make just one point. There are some peculiar situations as set forth in the instructions that if an alternative work stream is suggested, and say that work stream involves a joint audit or something, and the folks who in the IRS who deal with that other work stream don't accept that work stream, then the taxpayer could be back doing an APA. So the the analysis of the alternatives and who accepts or who declines has to be very carefully examined to figure out what the next step is. And obviously we can't go through all of those iterations here. But Josh, now we've cleared the first step. What happens in the APA request process?
Yep, if we can go to the next slide. So, once you've been approved on the pre-approval process, then you're asked to file a full submission, and we'll cover some of the factors, but basically Atma has 8 weeks to review the submission and then communicate orally to the taxpayer and let them know whether they're in or out of the program. So, and if the APA request is denied, then it's possible or likely that Atma will recommend alternative transfer pricing work streams. If we can go to the next slide. So, the review is pretty hands-on. So there's a team that includes an economist or a team leader, treaty assistants, an interpretation team, analyst, and then a manager or designee and a transfer pricing practice reviewer. And the team reviews the submission, decides the best path or the best apologies, my phone's ringing, the best path for a work stream for the transaction. And then at that point, Atma will then accept the request or decline to enter into the APA process with the taxpayer and recommend that alternative work stream. Atma may require the taxpayer to agree to conditions, and so let's turn to the next slide. So very much like the pre-filing process, the filing process requires multiple factors to be considered, and even though a taxpayer may satisfy have gotten through the original round under the pre-filing process, taxpayer could still be knocked out of the APA process with the second, more in-depth review. And very much like the initial pre-filing review, the factors for APA review are a combination of taxpayer-specific items, but then also a variety of factors involving Atma's capacity, the other country, etc. So there's really a lot of factors that have to be taken into account. And so maybe, Alan, should we bring in the other panelists to give their thoughts about?
Yes, I think so. Sergio and Mario, Jim, but any further thoughts on all of this stuff?
No, I think the slides really do show you that, the factors that the evaluation that's going to occur is rather extensive and intensive. And these slides show that out. I mean, I really think at the end of the day, you have to be aware that when you, going back to your previous practice, before this informal guidance was issued, you're correct. What you thought you were going to get when you filed an APA isn't necessarily on a going forward basis going to be applicable. So I would strongly recommend everybody to take a look at these two slides.
Jim, anything else before we go on just to the last part of this?
I would, Alan, we got like less than 30 minutes. I would love to hear from the Mexico side presentation. Maybe we want to jump forward.
No, I think I was just going to make the point. We have about 30 minutes left. The slides 32 through really the end of the thing are self-explanatory. I think we've covered most of the points. And so if we now are at slide 38, really slide 39, I'm going to turn it over to Mario, and then he and Sergio can go through both their reactions to this new guidance as well as the treaty points, and we'll chime in as we think appropriate. So let me turn it over to Mario, please.
Thank you, Alan, and thank you all. Well, I think, first of all, my first reaction is that it is quite refreshing to see that some jurisdiction has some guidance in terms of this process, or any tax process for that matter. In Mexico, unfortunately, that is not always the case. I should begin by saying that we do have an APA program, which also aims to avoid future controversies, and also intends to provide a certain degree of certainty. But we have some differences vis-a-vis the process that may be in place in the US. First of all, the requests are non-discretionary in terms that the tax authority has to process them. Of course, they don't have to agree with you, but they are constitutionally required to analyze the matter, to analyze the application. But again, it doesn't have to agree with you. Assuming that it doesn't, well, that is not a decision that may be subject to any judicial or administrative review. On the other hand, if the tax authority does agree with taxpayer, it issues a binding ruling. We see it as a ruling, not so much as a contract, like it seems to be the case in the US. It is binding to the tax authority, which means that it cannot deny it by itself. It has to challenge it in court, and to do that, it has 5 years. Thereafter, it cannot be challenged at all. Similar to what we see in the US, there is a rollback. In general terms, the APA will be binding for the year in which it's filed, the previous year, and the 3 next years. Of course, it may be renewed, but that is in principle its validity. Having said that, there may be constraints with regard to this APA process, just like Sergio mentioned some moments ago, in terms that the tax authority may not be that willing to enter into this APA process, simply because it doesn't want, I mean, the public officials may not be willing to stick their necks out in terms of that they get into responsibility of somehow. So from a practical perspective, it is not that easy to get a favorable APA from the Mexican tax authority. If we move on to the next one, please. Just like I mentioned before, how does it relate the APA program in Mexico vis-a-vis this guidance that is in place in the US? Well, there's simply no guidance in Mexico, let alone a pre-check. The statute mainly provides that the taxpayer must provide enough information and documentation so that the tax authority may rule upon that. And there is a lot of subjectivity in terms of what is enough. Typically, what we do is to put together the dossier, the files, and provide it to a tax authority, and maybe the tax authority will get back to us with a further request for information, but there is, again, no clear guidance on what they may be looking at. You need to provide as much as you can in terms of documentation, but again, there is no guidance. There may be yet informal oral consultations. That depends really on the officials involved. They may be willing to talk to you pre-filing or after filing, and to tell you how they look at things, and maybe provide you with suggestions to enhance your dossier, but that's it. It is not a formal process. And most important, the tax authority or the officials concerned may back down from whatever they said, because again, this is something very informal. In my experience, they haven't done so far. I mean, whenever they say, well, you should add this or that to your file, they honor what they said, but there is still a possibility that they may back down from whatever they say. Another issue that has come up recently is certain amendments to our Income Tax Act that repeal having an APA as a possibility to qualify for the safe harbor rules in terms of transfer pricing, and to avoid the creation of a permanent establishment or a PE. That doesn't help really for the case of an APA, because unfortunately the rules are not that clear in terms of what happens to the APAs that were already being processed at the moment that these amendments came into place, or more importantly, what is going to happen to APAs that already were granted before the entry into force of this amendment and yet are still valid. That is something that there is, again, no guidance as to what happens prospectively. So taxpayers are now inquiring themselves whether they should try to qualify for another alternative for the safe harbor rules, or they should simply stick to their current APAs, or what should be next. The next one, please. How do we see this? At least from my perspective, it's good news to have some guidance, to have some more certainty for the taxpayers, and that, in my view, that is the essence of an APA. Like I said before, it is aimed to avoid controversies, and it is aimed to improve efficiency. Now, being this a set of rules that are in place in the US, they certainly don't apply for Mexico or to a tax authority. A non-Mexican APA, it is not binding at all to a tax authority, but from a practical perspective, the outcome of a pre-submission may be used to encourage the Mexican tax authority to enter into bilateral APA, that which would ultimately provide for the uncertainty to the taxpayer, because if you actually get a bilateral APA, you get an answer from both sides of the equation, while an unilateral APA just sees one of the ends of the equation. The advantages of the bilateral APA or a BAPA are that it's binding for the Mexican tax authority. It cannot be challenged in any way, and thus it really provides for the uncertainty. And in that sense, I would like to turn over to Sergio to see if, from his standpoint, this guidance, to some extent, if any, really create some appetite for an APA from his perspective.
Yes, I agree with you, Mario, that the Mexican tax authorities should follow the US in terms of this implementation of guidelines, and to have more clear guidelines for Mexican taxpayers to apply for an APA. But I believe that we are in agreement that it's important for all taxpayers to evaluate if the APA is the best course of action in order to gain the certainty that we want to have for a particular transaction, right? So definitely the point of view that we have in CEMEX is evaluate if we should or not apply for an APA in a specific country, and go for it. For example, it's not Mexico, but we have an APA in Poland for royalties and management fees that, again, we have been in the program for the past 5 years, and now we are in the process of renewing the APA, and it has been a good program for us because it has given us the certainty that we need from a Polish perspective. In Mexico is different because the holding company is based in Mexico and is more an inflow of income from other countries. So we don't have at this point any, or we have evaluate our risk, and we don't think that makes any merit to go for an APA in Mexico. But again, it's an assessment that we do on country by country basis, and in order to define what to do in each particular case. As explained at the beginning of the conversation, in the USA, we were part of this CAP program that gave us the certainty that we require. In Poland, we have this APA, and for example, in another country, in UK, we are part of a program where the HMRC, which is equivalent to the IRS in the US, have assigned a specific team to our account, and they do on regular basis risk management assessments. So they evaluate from a risk perspective how risks or not are our UK company from a transfer pricing perspective. And again, this is not an APA, but it's a program that has given us the certainty that we require from a tax perspective in UK. So this is the type of example that I wanted to provide in this webinar, that basically it depends on, at least from a CEMEX perspective, is we evaluate the risk in each particular country to decide which is the best strategy we should follow from a tax and transfer pricing perspective.
Yeah, I think the point you're making, Sergio, is a really important takeaway for what we were trying to cover. There's no specific answer per country. Yes. I think, sort of saying it another way, what the interim guidance really is providing taxpayers now is evaluate, as you said, what the risks are in a particular country, unilaterally, bilaterally, multilaterally. Look at the different work streams that are available on each side of the ocean, figure out what to do. And I think maybe that's sort of the optimum approach that would be made going forward. And then we'll see here in the United States what comes to pass in terms of more or less APAs. But I think that guidance is maybe a perfect way to end the discussion of all this APA business and turn to the treaty stuff you're going to cover, unless there are further comments from any of our panelists. So turning to treaties, Mario, and whatever else to talk about.
Thank you, Sergio. Thank you, Alan. If we may go to the next slide, please. Thank you. Just like Sergio and Alan mentioned, an APA is one alternative, and there is no rule of thumb. Another alternative is an APA or a bilateral APA or BAPA versus a MAP, or a mutual agreement procedure. As you know, whenever you actually have a measure from one contracting state, here in the bilateral relationship between Mexico and the US, let's say Mexico, that seems to be inconsistent with the tax treaty, you may try to find relief in this kind of procedure. So the question is whether people should rather aim for an APA or a BAPA or rather a MAP. And there are different arguments for one or the other. First of all, an APA is prospective in terms that you don't have currently a potential contingency, a potential controversy with tax authority, but you actually are trying to prevent that. Conversely, whenever you are within a MAP, you already have a contingency with all that pressure that may be associated to that. There may be also procedural issues associated to a MAP, particularly where it comes to the tax treaty between the US and Mexico. The term for filing for a MAP is 4.5 years after the relevant tax return has been filed. Unfortunately, in Mexico, tax examinations come 3 years or 4 years down the road after a tax return is filed. So whenever we actually have a tax examination, there may be very little time, or sometimes even no time, to file for a MAP, which may be also a problem. Conversely, in an IPA, you may have practically all the time of the world to have your file as robust as possible in order to get the result that you want. In the MAP procedure, that may not be the case. Also, within the context of a tax examination, there may be issues that are not governed by a tax treaty, typically VAT. So that the MAP will not get into that. So if you go through a MAP, you may be able to solve the transfer pricing issues, for example, which is an income tax issue after all, but the VAT issues have to be solved in a different way, maybe through litigation. Conversely, if you go for an APA, although there is a special provision that governs APAs, transfer pricing APAs, but you may also ask for advance letter rulings for other types of tax issues. So you should be able to comprehensively tackle all the tax issues that you may be facing at a given point in time. That goes all the way to the scope of the MAP. The MAP only will cover 3 issues: transfer pricing, withholding, and so on, but not other issues that may be, for example, entirely domestically, or that may be associated to other taxes, like I mentioned before. And last but not least, what if there is no consensus? As you know, the tax authorities are welcome to enter into discussions, to enter into consultations, but there is no need to enter into any kind of agreement. So what happens next? It may be the case that after two years or 3 years of waiting for your MAP to be solved, you end up in court anyways, with the waste of time associated to it, and not and more importantly, your tax contingency continues to grow because interest and inflation adjustment continues to accrue. So in essence, well, while the map is maybe a helpful tool, whenever you are planning an APA or maybe another alternative, maybe more suitable to a particular situation. Next, please.
Mario, before you
Yes.
continue, just two comments, sort of interrelated. In terms of the US practice, though you say APAs are prospective, if one is requesting an APA, many of the years of prospectivity may have passed before you get the APA, depending on the circumstances. And then the second point is the US, I don't know if Mexico has this at all, has negotiated various tax treaties that have an arbitration clause, as if you can't reach agreement. And that's one of the factors in our interim guidance that they look at. So, I think they're seeking a resolution as best they can. I just wanted to add those 2 points.
Yes, absolutely. Now, I wanted to single out the maquiladora situation. Just like I mentioned before, maquiladoras are in essence toll manufacturers that by their very nature should be inconsistent with the arm's length standard and should create a permanent establishment. Yet, the Mexican policy for a number of years has been to allow maquiladoras to be in place because it helps in terms of creation of employment a lot. And in line of this, there are a few alternatives that you may qualify so that your maquiladora operation does not create a permanent establishment for the principal, for example, that is located in the US, and that the consideration agreed between the maquiladora and its principal qualified for the safe harbor rules. Unfortunately, as of last year, the possibility of securing an APA as one of the options to qualify for these rules was repealed. And as I mentioned before, there is unfortunately no interim guidance, speaking about interim guidance, that may allow taxpayers to know what is going to happen to the requests for the APA applications that were already in place while these amendments came into force, and more importantly, what is going to happen to the APAs that are already in place and that cover years subsequent to the entry into force of this law. The main issue here is whether the taxpayers may continue relying on their APAs for transfer pricing purposes and for not creating the PE, or to the contrary, they need to seek yet another alternative to continue qualifying for these safe harbor rules.
Could they do something under the competent authority mutual agreement procedure, or is that not a
actually that may be a case for the map, certainly, of course. Now that you mentioned that. Yeah.
Okay. We have about 8 minutes left, just to give you the timing on your
discussion. I know. We're almost there.
Fine. We're fine.
If we will go to the next. Moving a little bit apart from these APA things and issues, we thought it would be useful to talk just a little bit about the 2 tax issues that we've been facing recently in Mexico, because they also touch tax treaties just like the APAs or the bilateral APAs. As you know, in terms of a tax treaty, and according to the comments from the OECD, whenever you have an item of income, you have to place that item of income within an article that especially deals with that article of income. For example, you have an interest, you have to look for the Article 11, which is with interest, and so on, with royalties, dividends, and so on. And whenever you have an item of income that derives from commercial activities that is not specifically dealt with, you have to go to business profits, which typically appears on Article 7, and that is in essence entails that such item of income should be taxed only in the state of residence and not in the source residence. Well, in line with this, we see that given recent court precedents here in Mexico have ruled that expenses related to marketing, publicity, and technical assistance do not qualify for treaty relief on the grounds that typically these items are not specifically dealt with in a particular article of the relevant treaty. And yet, they shouldn't qualify as business profits because there is this crazy provision in the Income Tax Act that says that these types of income, whenever they are earned by a foreign resident, should not be considered commercial activities. So, in the opinion of this court, these items of income should not qualify for any relief, and therefore they should be taxed on their domestic law alone. In our view, that is an unfortunate precedent. Actually, there are two precedents. They are both unfortunate because they really do not construe the tax treaty in harmony with the OECD commentaries. And in addition to that, it really entails a treaty override because in light of a domestic provision, they are denying treaty benefits. And that is something that we have. It is not binding to other courts, but it is possible that other courts in similar cases may take the same approach. So that is the sort of issue that may be best resolved under a map.
Yeah, what about, Mario, the other income article that deals with, types of income not otherwise covered by the treaty? Could that article apply?
The president does not address that, but that wouldn't provide further relief because it typically just resends you to domestic law. So the end result would be the same. But at the end of the day, if you have a company that is providing this marketing or publicity, in my view, at least, any income that it earns is actually a business profit. So it should belong to Article 7 rather than the other income article.
Anything else on the treaty stuff before we finish? What I thought we have 5 minutes, well, we have 2.5 minutes left. Maybe we can do a quick lightning round, just every person, 20, 30 seconds. Just any final takeaway. And Sergio, why don't you start if you have any quick takeaway for the audience?
Well, it's as you mentioned, assess the different possibilities and options that you have in each particular country, right? And of course, an APA is a very good option, but there are also other options applicable.
Thank you. Jim?
Sure. I mean, 30-second, the new guidance is a game changer. It puts the reasons why the APAs were created on its head, whether it be because of Eaton or other matters. Taxpayers have to go back and look at the alternatives and unfortunately be prepared for the prospect of litigation.
Mario?
I think APAs are a good alternative. They may enhance if they become bilateral, but yet again, it is only one option among many that taxpayers may have.
Josh?
Well, even though I think I agree with Jim that this flips the APAs on their head, the guidance, we only have one piece of the guidance coming out, and I'm looking forward to seeing the revised RevProc and what additional requirements are added to qualify for an APA.
And let me just comment, which we've mentioned, I think looking at various options to resolve transfer pricing situations in different countries, as Sergio mentioned, really seems to be the way to go. Well, let me thank you, our audience, for attending. I hope you found it useful, and thank our terrific panelists for their observations, both from Mexico and the United States. And also, I'd like to thank our colleagues who supported the the transmission of this, and Erica and the remainder of our colleagues. So thank you very much, and until next time. And if you have any questions, just drop us a note and you'll be getting the link to the presentation and the slide deck in the next few days. So thank you and stay safe, and we hope to see you soon again. Bye-bye.
Thank you.
Thank you. Bye-bye.